Good afternoon and welcome everyone who has joined this session. It is the fourth session of international and European law. My name is Carmen Moldovan. I am a lecturer at the University Alexandru Ioan Cuza of Iași. I will be chair of this session. I am very pleased to meet you all. There are four panelists in this session, and the schedule according to the schedule, we will meet Professor Orsolia Zibeg from the University of Szeged. Please excuse my bad pronunciation. And we will meet Mr. Donald Verlem from the Comenius University in Bratislava. Mr. Christoph Ormandi from the University of Szeged, and Mr. Benci Krusowski from the University of Szeged. Okay, so we will start with Professor Zibeg from the University of Szeged. Your team is your topic is very interesting. On ecocide, the new old international crime, balancing approaches and possible results. You have the floor.
Thank you for the floor. Good afternoon, dear chair, dear colleagues from Szeged, other colleagues from other countries, and dear all. I'm trying to share my screen because I prepared a PPT presentation, so hopefully it works. Can you see it? You can see it?
Yes, it's fine.
Oh, thank you. So, firstly, I would like to introduce myself shortly. My name is Orsolia Johanna Zibeg, and unfortunately, I'm not a professor yet, but I'm a senior lecturer at the University of Szeged Faculty of Law and Political Sciences, Department of International and European Law. And I'm really happy that you found my topic, today's topic, interesting, because I think it's a really interesting part of international law, yet it's not so it's not so commonly can be appeared in literature, or you cannot hear a lot about that topic. So the title of my presentation is Ecocide, the not yet old international crime, shifting approaches and possible outcomes. And the logic of my presentation follows the title I have given to my presentation, because first of all, I will talk about the history of ecocide and answer the question, why is it old? Secondly, I will talk about the different definitions of ecocide that you can find in literature or even in articles and other sources. So I will talk about the different views about the definition of ecocide. Third, I will talk about the current trends and the different approaches that are appearing at the international sphere about ecocide. And last but not least, I will talk about the future of ecocide legislation and answer the question, why is it new? So let's start with the first topic, that is the history of ecocide, and answering the question, why is it old? So when it comes to the environmental harm, environmental pollution, and even environmental destruction, these kind of happenings and activities are becoming extremely common because of the Industrial Revolution. And because of this, I think so that states and even humanity considers environmental harm, pollution, and even destruction acceptable in some kind of in an extent, but there are some activities that are overstepping the acceptable boundaries of environmental harm. And one of the greatest examples about these activities is about the Vietnam War effort of the United States of America, especially concerning the 1960s and the beginning of the 1970s, where the United States of America, as part of the Vietnam War effort, used and sprayed more than 73 million liters of chemical agents to this territory because of different war activities, and also targeted cultivated land, destroyed crops, and other, for example, the crops and rice production were also destroyed, and serious environmental damage happened. So this Vietnam War effort from the United States of America was I think, the first and greatest example about ecocide. And not later, in 1972, I think you are all aware of the Stockholm Conference on Human Environment. That was the first and biggest conference at the field of environmental activities and environmental law. And at the Stockholm Conference, Olof Palme, who was the Swedish Prime Minister at the time of the conference, called out the United States of America and used the word outrage in connection with all of the activities that were conducted as part of the Vietnam War effort. And this was the first time when the term ecocide actually appeared in the international sphere and on conferences. And one of the greatest results of this conference on the human environment was the creation of a working group on crimes against the environment that was established in order to search for means how ecocide can incorporate it into public international law and to the field of the international relations. And later, also an ecocide convention was accepted and drafted that actually completely disappeared from the sphere a year later. So it's interesting because you actually cannot find any exact literature about the wording about the ecocide convention and even the effect of the ecocide convention. But in 1973, this convention was actually drafted because, as you can see this quote, that man has consciously and unconsciously inflicted irreparable damage to the environment in times of war and even during times of peace. And this is why actually this ecocide convention was drafted. So these were the first historical approaches when actually the term of ecocide appeared. The first time actually of the term ecocide appeared, we have to go back to 1970 to the Conference on War and National Responsibility, where Arthur Galston professor used this term ecocide first time in history. Interestingly, Galston professor wasn't a lawyer. He was actually a really great biochemist and botanist, and he was working at the field, so in he was working at different fields. But this was the first time when Galston professor actually called out the United States of America because the things that were happening during the Vietnam War, and this was the first time in history when the term ecocide appeared at the international sphere. So how about this term ecocide? Because if you imagine these words together, I think firstly it's a bit hard to understand, but ecocide practically means killing our home. I think it's very kind of a good wording because you can imagine the content of this term easily. So ecocide actually is a combination of two words that means home and demolish or kill in English. And if you add these two words, this combination can be results ecocide, that means killing our home. And I think the biggest question of public international nowadays when it comes to the ecocide and this term and the whole sphere is to answer the question, how can the most serious activities be punished as international crimes? Because if you think this part to the public international law, international crimes, it's quite a new era of public international law because it's first appeared after the Second World War. But it's very interesting that you cannot really hear about the ecocide part of international crimes. Meanwhile, it has already appeared in the 1970s, so not so later after the Second World War, when the part of international crimes were already differentiating, and you can find this literature about other international crimes. When it comes to the history of ecocide, we also have to mention the ecocide and the connection with the International Law Commission. I think you are all familiar with the International Law Commission, so I really would like to concentrate to the ecocide part of the work of the International Law Commission. So very interesting that the ecocide appeared in the work of the International Law Commission from the 1980s till the middle of the 1990s. And actually, the International Law Commission has debates about ecocide many times because even the wording of environmental crimes were quite debated. For example, when it comes to the wording and the terms of human or natural environment and the usage of these words and the difference between human or natural environment, when it comes to the seriousness of the crime, ecocide and other environmental damage, the International Law Commission also had quite a strong debate about the seriousness of environmental damage. And also when it comes to the real criminal issues, the disputes were mainly about the psychological elements, so the willfulness of the ecocide and other environmental crimes. So interestingly, as you can see, the ecocide appeared as part of the communication and even the disputes of the International Law Commission from the 1980s, where actually the International Law Commission were debating the draft code of crimes against peace and security of mankind. And actually, this draft contained one separate article about ecocide. The 26th article of the draft convention was concerning ecocide and environmental crimes and environmental damage as part of the crimes against peace and the security of mankind. But because if you are thinking to these kind of debates about the term and definition of ecocide, the wording was different when it comes to the actual article. Because in 1991, the draft contained the willful and severe damage to the environment, and 5 years later, because of the debate and other recommendations of the representatives of the states, they changed this willful and severe damage to the environment to widespread, long-term and severe damage to the natural environment. And you can see that the wording is really different, because when it comes to the term that was used in 1991, you can see that willful, the severe damage is the same in the wording in 1996, but you can see that they changed the environment term to the natural environment. So if you can see the results of these oncoming debates between human or natural environment, this was a core issue for the International Law Commission and also for the states and the states representatives. And in 1995, also a working commission about ecocide was established, and their work resulted a report in 1996. And in 1996, this report offered 3 different ways how ecocide and environmental crime can be incorporated to the draft. The first solution was the inclusion to the draft as part of the crimes against peace and security of mankind, so kind of one form of these kind of crimes. The second recommendation of the Working Commission was about a creation of a so-called autonomous crime, so ecocide can be incorporated to the draft as a separate crime. And last but not least, they recommended to punish as form of a war crime, so ecocide can be punished as one form of war crimes. So the Working Commission offered 3 different solutions how ecocide can be incorporated to the draft. But interestingly, in the same year, in 1996, the whole ecocide concept had completely disappeared from the work of the International Law Commission without any kind of vote. And it's really interesting because voting is one of the main parts of the work of the International Law Commission, where actually the representatives can have a word about what to incorporate or even what to exclude from the drafts that are on the table of the International Law Commission. So it's really interesting how ecocide had completely disappeared from the whole draft and even from the table of the International Law Commission. But environmental concerns found their way to the Rome Statute. You know that the Rome Statute was kind of a basic document of the International Criminal Court. So it's one of the greatest, I have to say this word, greatest conventions when it comes to the international sphere. And environmental concerns are at the Rome Statute as part of the war crimes. So if you remember back to the recommendations of the Working Commission that was established in 1995, they actually recommended this kind of solution that ecocide can be incorporated to the draft as a form of war crimes. And actually the Rome Statute used this kind of logic, because you can find not ecocide but environmental damage, as you can see the highlighted parts of the Rome Statute. You can see that this kind of so-called severe damage, long-term environmental damage, is incorporated to the Rome Statute as part of the war crimes, but not as ecocide. So when it comes to the definition of ecocide, because of the historical background, I think it's really important to settle what can be considered as ecocide. It's not easy because actually you cannot find any universally accepted legal definition to ecocide. So from literature to literature, you can find different definitions about this topic. The general term is the devastation and destruction of the environment to the detriment of life. So ecocide is something in between an international crime and the serious damage of the environment. But in literature, you can find some definitions. Professor Bodnar, who is actually a professor at my university and my department, wrote a really great article about ecocide in Hungarian in 1974. So you can see that it's kind of, this happened after the Stockholm Conference and after ecocide was incorporated to the international legal sphere. And Laszlo Bodnar recommended the definition of ecocide as the following. The delictum of ecocide is committed by a state that intentionally damages or destroys the human environment to such an extent that it may lead to an ecological imbalance outside the territory of its own state. So you can see here that the definition, I highlighted the most important part, considers only the act of the state and considers human environment and the ecological imbalance as a result of the acts of the state. When it comes to the newest definitions that were created mainly by activists and lawyers, you can see the definition of Polly Higgins, who was, I think, the greatest lawyers at the sphere of ecocide because she actually sentenced her whole career to ecocide. So when it comes to the definition of Polly Higgins, in 2010, she recommended the ecocide as the following. Ecocide is the extensive damage to destruction or loss of ecosystems of a given territory, whether by human agency or by other causes, to such an extent that peaceful enjoyment of the inhabitants of that territory has been severely diminished. So you can see that there is a lot of differences between the definition in the literature and the definition that are actually created by the activists, by the lawyers who are for ecocide legislation. I don't want to go into the definitionary part because it's really a lengthy process, but here you can see the differences between the different ecocide definitions. And also when it comes to the European Union sphere, you can find a citizens' initiative sentenced to the earth rights and an ecocide as a criminal act. Unfortunately, this citizens' initiative was failed in 2014, so we cannot mention that actually the European Union considers ecocide as a current dispute, but you can see the definition that was given as part of this citizens' initiative, and you can also see the most important parts as extensive damage or destruction and the alteration of global commons or earth ecological systems. And also you can find ecocide national legislation as ecocide, so not as generally environmental damage or environmental destruction, but some countries, not so many countries, because maybe a dozen of countries had already completed ecocide legislation as part of the national legislation. For example, Kyrgyzstan, as part of the criminal code, or the Russian Federation calls upon these kind of crimes. And you can see that the wording is really similar in the national legislation that actually considers ecocide as a criminal act, because you can see the massive destruction, the contamination of the atmosphere, other sectors of the environment, and the commission or acts that are actually causing this kind of serious damage. I also listed some other countries that incorporated ecocide to the legislation, to the national legislation, but I have to say that here you really importantly have to differentiate the normal environmental legislation of the countries and the ecocide legislation, because it's different. And thirdly, I would like to talk about the current trends and the different approaches concerning ecocide. Because of the activists and the lawyers who are really for ecocide legislation, we can mention that even the amendment of the Rome Statute, so the Rome Statute amendment is also considered as part of the ecocide thinking, because in 2010, the already mentioned lawyer Polly Higgins recommended that the Rome Statute has to be amended by ecocide, and she actually has submitted a draft about ecocide legislation and how the Rome Statute has to be amended. And this proposal was kind of a big step because it started a negotiation among the states of the international community, and also the ecocide found its way to the international literature again. That was a great happening at the international sphere. And last year, at the 18th Assembly of the States Parties of the ICC, the International Criminal Court, a side event was also held, and the topic of this side event was the ecocide and how the ecocide legislation can be incorporated to the Rome Statute, or how it can be incorporated to the sphere of international crimes. I think I don't want to go into details about the new happenings, but you can see some research that were conducted in the last couple of years about ecocide. There we can mention a very great French lawyer and again an ecocide research, but you can see that even the new happenings at the literature is quite limited. And why the inclusion of ecocide law is important to the international law? Give some reasoning. I don't want to say that this really considers my full opinion. I just would like to show you how the activists really reason why ecocide has to be incorporated to the international criminal law. First of all, we have to say that the ecocide legislation can prohibit mass damage and destruction of the earth and creates a legal duty of care for the states, because if you just imagine the really different approaches, how actually the states considers the rights of earth, for example, it's really different in a South American country and really different in the European Union. So you can see that there are really different approaches, and the ecocide legislation can somehow create a generally accepted duty of care about the earth and environmental aspects. And also ecocide legislation can prevent, prohibit, and even preempt both human-caused ecocide and natural catastrophes, because the ecocide legislation considers not just the state acts, but also natural catastrophes and also other natural occurrings that can actually change the earth and the environment. And last but not least, because of the ecocide legislation, a remedy can be sought through national courts or even at the international field, for example, in front of the International Criminal Court or other similar bodies. And last but not least, in the last maybe 5 or 10 minutes to fit into my time frame, I would like to talk about the future of ecocide legislation and answer the question, why is it new? So when it comes to legal acceptance of ecocide, I have to say that legal acceptance of ecocide is growing, and there is a big but in this aspect, because ecocide appears only in some states' national legislation. I mentioned a couple of examples, and I have already explained why it is really important to differentiate between the normal environmental crimes and environmental criminal legislation even of the states and ecocide. And also, the term ecocide appears in the definitions and in the wording of some judicial forums. For example, in one case, the Indian High Court also established the term ecocide, and you can find this term in the Environmental Court of Guatemala, one actually case of this court. But we have to say that ecocide and serious environmental harm really influences the full enjoyment of fundamental and human rights. And this is what already established in 1994 in the report on human rights and the environment, because this report highlighted that in the enjoyment of fundamental rights and human rights, it's really important that environmental issues also have to be concerned. And in a case in 2015, that is actually a really interesting case, in the Inuit petition also considered ecocide, because the Inuit people started a procedure before the Inter-American Commission on Human Rights for dangerous impacts of climate change, because they considered that the acts or even the lack of acts of Canada and the United States of America, it really influences climate change and throughout the rights of the Inuit peoples. Unfortunately, the Inter-American Commission of Human Rights considered this petition out of the scope of the convention, but it really interestingly appeared or make ecocide appear in front of international judicial forums. So the Inuit petition actually is a great example how ecocide trying to find its way to the judicial forums as well. And also nowadays, intergenerational equity and the rights of future generations have to be considered on a full extent. So in this regard, I think so that ecocide became so important nowadays, and to talk about environmental harm and the criminal aspects of environmental harm, because without this, ecocide cannot be incorporated to the international legislation. But if you would like to find examples what can be considered as ecocide, you can find a map actually created by the Environmental Justice Organization, Liabilities and Trade, and this is the Environmental Justice Atlas, where you can find global activities and a database of global activities that can be considered as ecocide, or they can be later considered as ecocide. These activities called potential ecocide cases, and also you can find culture ecocide when the environmental harm influences the enjoyment of indigenous rights. So actually the Inuit petition about the Arctic activities and climate change falls to this cultural ecocide term. To answer the question whether I am or the lawyers generally are for or against ecocide, it's really hard to say that I am for ecocide because I am for ecocide actually, but you can find several reasonings against ecocide. For example, we can say that we are for the ecocide legislation because of the environmental damages we are really experiencing nowadays, and even the enjoyment of the human rights can be mentioned. On the other hand, the economic development, equality of the states, the sovereignty of the states, and can be mentioned as other consequences of the ecocide legislation, because ecocide legislation will influence the sovereignty of the states and economic development and even the equality of the states. And one reason against ecocide legislation is that other serious crimes, for example human trafficking or drug trafficking or even other kinds of really serious acts, are not included to the International Criminal Court statute, to the Rome statute. So why ecocide? Why the environment has to enjoy this kind of protection? And you can see that we have to be really aware of the different elements, being psychological or material elements of this kind of crime, because of the principle of legality, and how to create a new international crime is quite complicated. So we have to be aware of the legal background of this whole issue. Possible solutions in 1 minute. I have to say that I think it's the easiest to amend the Rome Statute with a new International Criminal Act. On the other hand, you know that how to amend an international convention, it's a lengthy procedure, and we have to consider other aspects of legality I have already mentioned. Another solution is to draft a new international convention considering ecocide as a crime against peace. I don't really see a chance to draft a new international convention because, again, it's not so well, I think, accepted by the international community. Another solution is the national legislation, and it again raises how international sphere can react to national legislation that it cannot. So national legislation cannot solve an international solution. It can happen that ecocide disappears from the sight of the international community, but I don't think so, because environmental harm and the rights of future generations are considered as really important issues nowadays. Maybe the interpretation of human rights conventions and the relevant judicial forums can serve, for example, throughout climate litigation and other environmentally related petitions. Maybe they can serve as a solution throughout the interpretation of the existing human rights conventions. But again, it's hard to believe that, because if you see the examples, for example, in the Inuit petition, it's really refrained the scope of the Inter-American Commission. And I would like to finish my presentation with a quote from Polly Higgins. I am someone who cares deeply about the earth. I am also a lawyer who loves earth. It's not often lawyers talk about love. It can feel strange to do so. However, I believe love and law can be brought together, and when the two meet, the potential to create new laws that put people and planet first is born. I really consider this topic a really important part of the public international law, and actually working at the field of international and European environmental law. So I think this topic is really important, but we are not talking about ecocide a lot. So it's really important to incorporate this topic to our day-to-day conversation and to raise awareness about environmental issues. And with these words, I would like to thank you for your attention. And if you have any comments or questions, please don't hesitate to write me or send an email or anything. On many platforms you can reach me, so please don't hesitate to send me a message. Thank you for your attention, and thank you for the possibility to present my thoughts.
Thank you for such an insightful presentation. I welcome any questions or observations or remarks from the panelists.
Okay, so first of all, I would like to thank you, Orsolya, for the presentation. It was very heartfelt and also very well drawn. The graphics were really amazing. So I have two questions. One of which is that I didn't really get the meaning, the core of this issue. So let's say that, for example, you would be the president of the UN or the president of the United States and you manage to pass this law against the ecocide. What would be a fitting punishment against it? So would it be a life sentence or maybe a death sentence? And the second question would be that why do you think only the Eastern nations were the only ones that incorporated this into the laws? So why not, for example, Europe, or why not America or Taiwan?
Are you waiting for other questions, or shall I answer now?
No, you may answer now.
Okay, thank you. Well, thank you, Christoph, for your questions. Actually, they are really good questions. Well, to get the core of the issue and the punishment side, it would be equal as in the case of other actually criminal international crimes. So they would like to incorporate ecocide to their own statute in the same aspect, for example, other war crimes. Actually the same, with the same punishment, the same consequences. So it's really interesting to see, because ecocide was actually in the draft convention as the other crimes, but it's strange for us because it has completely disappeared from the draft. So you cannot imagine that, okay, because, for example, pollution or because of environmental harm, they can use the same consequences and they can actually, for example, punish somebody with a life sentence because of, ecocide. So, but the same results and the same consequences are actually used in this case, in the case of ecocide and in the other war crimes and other, criminal activities. So the same consequences, actually. So this is my first answer. And the second, why Eastern nations? It's really interesting, and it was actually quite surprising for me as well, because this is kind of a new research area for me. I have just started to work at this field like 3 months ago, but I was really astonished by the fact that the Eastern nations are incorporated to the ecocide legislation, to the criminal codes. I think it's just surprising, firstly, because, for example, during the Soviet era, they caused serious environmental damage at that area. I think you are all aware of that. And I think this is one actually reason why the Eastern countries and Eastern nations incorporated ecocide legislation, because they have been really influenced by the environmental damage in the last 50 years. So, for example, small island countries are for ecocide legislation because of, the rise of the sea level. They are really actually frightened of the fact they lose everything and the whole island where they actually live. So this is why I think Eastern nations are for ecocide legislation, because they really experiencing the results of serious environmental harm and damage. Meanwhile, at the European sphere, I think we are kind of restricted from this kind of information and experiences. So I think this is the reason, but this is just a thinking of mine, because I don't know the actual reason, but I think that's the reason. Thank you for your question.
Okay, thank you. Just one comment more. So if Russia cares so much, then why don't they, for example, want to sign the Tokyo Convention? What is your idea about that?
Well, I have to say that if I know the reason, I think I would sit in the United Nations now. That I think these kind of complicated things when it comes to the politics and the environmental, the international environmental legislation, international environmental conventions and other things, it's more about politics than the actual, content of the environmental legislation. And all of the countries actually have some kind of environmental legislation, domestic legislation, but you can still experience serious environmental damage throughout the world. So I think even if a country has national legislation about ecocide and environment, this doesn't mean that at the international field, this country is willing to incorporate new aspects of international environmental legislation to the domestic, obligations.
I can see it now. Okay, thank you very much for the answers.
Thank you for the questions.
Thank you. I have one small question. What do you think that the most efficient remedy would be?
Good question again. Well, the most efficient remedy, I think we have to somehow get to the point that we don't have to use the remedy. Because when it comes to environmental harm, you cannot, restore environment. You cannot use actually the same things and in other aspects, for example, and other forms of damage, because environment cannot be restored in the same status before the damage. So I think we have to somehow get to the point where we don't have to use a remedy. But to answer your question, I don't think so that it could be some kind of penalty that they have to pay, because money doesn't really matter in most of the cases when it comes to the environment. So to really restrain, for example, companies from the usage of technologies that are seriously harming the environment, I think it would be some kind of serious some kind of remedy. So not some kind of compensation, but even some criminal consequences of the act. So this is my opinion about that.
Thank you very much. If there are not any further questions, I think that we can move forward with our schedule. And moving forward, we will have the presentation of Mr. Donald Vertland from the Comenius University in Bratislava on the legal framework of the energy union in the EU. How does the European Union address the international goals of sustainable development? You have the floor.
Thank you very much, Carmen, for the floor. Also, thank Ursula for the presentation. It was really nice, and we will remain in the sphere of the environment and the legislation. So let me just share my PowerPoint as well.
If you would be so kind to take into consideration 20 minutes for your presentation, just to have enough time for discussions. Thank you.
Oh, okay.
Okay.
I will do my best to be concise.
We are flexible though, so.
So can you see it?
Yes.
Can you see the slide?
Yes, this is working.
This is working. Okay. So briefly to introduce myself, I'm Donald Vertland. I'm internal doctoral student at the Institute of the European Studies and International Relations. I deal primarily with the energy policy, and also in my dissertation with the incorporation of the climate in the energy policy. So I will bring a bit of political science approach also to this legislative and law issues. So the topic, as Carmen mentioned, the legal framework of the EU Energy Union and how the EU addresses the international sustainable development goals. And in order to make some sense of this, we'll briefly move through the context. As the topic of the whole the session of the conference, maybe the legal answers to the crisis from in this case, supranational perspective, as the EU considered a supranational actor. I picked up the climate change, really trending issue, a couple last years, which brings these significant implications for the human security either in the form of undermining the livelihood and human capital, or compromising the culture, increasing the migration, therefore constituting a bit of human insecurity. Therefore, I consider it one of the crises that really need to be addressed. And there were these multilateral efforts to combat the climate change, or to mitigate the climate change implications, as the climate change is a transboundary issue. It's hard for one nation, one state to do feasible work all alone. So, for example, the Paris Agreement and on the reduction of the greenhouse gases emissions, where the countries committed, or the United Nations Sustainable Goals. These are the examples of the multilateral efforts to reach. However, there are no legal obligations stemming from these. There is no enforcement mechanism stemming from these. So it's hard to measure the impact of the countries and how they to enforce the commitments. And here we come to we define this climate change as the crisis needing this thorough attention. And to connect it with the European Union, and what I'll be talking about later, the sustainable development as such is one of the core principles and values of the European Union, among others, as can be found and stipulated in the Treaty on the European Union. A part of the identity of the EU, we may say, currently is the Sustainable Development Agenda. And why do I look at the EU energy policy and EU energy legislation? It's pretty easy. Because the energy-related emissions accounted for almost 80% of the European Union's total greenhouse gas emissions, and therefore the EU took this stance on the energy transition and be more progressive, particularly in the field of the energy, in the context of the climate change mitigation. Looking at the legislation, in the pre-Lisbon era, traditionally energy has been the more intergovernmental domain. There were, as the countries were endowed differently in their consumption patterns and energy needs, energy production.
I'm sorry, Donald, your voice is shaking. Can you reconnect the camera?
We are experiencing some technical problems. I'm sure that Donald will be able to reconnect. Probably we should be patient for a few seconds.
I just wanted to say that I'm sorry if I exceeded the time, but I couldn't see the private chat during my presentation, and I couldn't see that you wrote at 6 to 5
Don't worry about it. It was very interesting, your presentation, and so new. So we were, I think that we all benefited from it.
Thank you.
You're welcome.
Yes, I'm sorry. I'm here.
So you're back. Okay.
Yeah, I'm really sorry. I don't know what happened. Like, everything is working. I got really strong connection, but never mind. So I will continue. I don't know where I finished. So was it somewhere here?
We cannot see the slide.
Reload.
This one?
We cannot see the slides.
You cannot see the slide? This
one. This is it.
This is it. And can you see it?
Yes.
Okay. Okay. So these technicalities. Oh my gosh. Okay, so the logic was to create the markets, to liberalize that, to create this functional spillover. Maybe the cooperation will lead to more cooperation in other areas of the energy, but the primary focus was on the market, and the legislation and the energy legislation reflected this, the structural and physical integration of the systems, the pipelines, the electricity grids, and the market competition to create this regulatory body on the area of the European Union. Also, the energy security, as you can see, and the solidarity between the member states was included in the energy legislation, particularly as a response to the 70s oil crisis and then 2006-2009 gas crisis. That member states decided that it would require more supranational approach. Therefore, it was included in the legislation. But the major milestone was the Lisbon Treaty, as it established the energy as the shared competence between the member states and the Union. Also, the member states maintained the sovereignty over the exploiting of the energy resources, the choices of the energy sources, and the structure of the energy supply, and negotiating the deals with the third country supplier to the country. So, still, the energy mix remained firmly in the hands of the member state. Nevertheless, the EU got for the first time formal competence in the sphere of energy, and this was really a assertive turn for the EU energy policy and legislation making, commencing the energy transition and going more to the coupling of the energy and climate. So it's maybe too early, but we can maybe see this as the start of the Europeanization of the energy policy, and also as the time developed, the Juncker's Commission launched the Energy Union, which could be perceived as the institutionalization or the institutional platform of the energy policy, with containing virtually all 5 reinforcing and interrelated dimensions: the energy security, energy market, energy efficiency, decarbonization of the economy, and research and innovation. And all future actions should be in line with these dimensions and to contribute to building this energy union. But what is interesting, and we're finally going to the more precise things, is in this post-Lisbon framework, the EU adopted this 2020 targets. It was in 2009. So until the 2020, the 2020 agenda, meaning that at least 20% cuts in the greenhouse gas emission, 20% share of renewable energy, and 20% improvement in the energy efficiency for the EU as such, applied on the EU level. But however, we know that the EU cannot do it as such. It's composed of these member states. Therefore, the member states need to adjust in order for EU to meet these targets. Therefore, they were adopted the directive on the promotion of the use of energy from the renewable sources, which set the binding national targets for the member states for raising their share of renewable energy in their consumption. These targets and this whole agenda adopted by the European Union was getting more ambitious and increased until the year 2030, also the 10-year period, which led to the recast of the 2020 agenda to virtually 40-30-32 agenda, recently to 55. That means 55 cuts in the greenhouse gas emissions, 32% share of renewables, and 32 improvements in the energy efficiency on the European level, composed of these member states. And there were amendments on both directives, on the promotion of the use of energy from renewable sources and also on the energy efficiency, setting the targets. But these benchmark targets remained the same as in the directive in 2009 and 2012, respectively. So, and the countries were lagging behind, some of them. And how it comes that the ambitions of the EU got larger, but there were no adjustments to the targets set on the individual level, came with the regulation from 2018 on the governance of the energy union and climate action, which requires the member states to draft the national energy and climate plans for the periods 2021 and 30, and then every 10 years, where they stipulate how they intend to achieve the national targets and contribute to the building of these 5 dimensions of the energy union. And besides this, the states must prepare also a long-term strategy how to how to achieve the climate neutrality or contribute to achieving climate neutrality on the European continent by 2050. Really ambitious target. So when dissecting this idea of these targets and this legislative, let's say climate-friendly legislative tools in the European energy policy, we may see like these 3 steps. The first is the adoption of the levels of the targets on the EU level. EU committed themselves to be first starting this 2020, and then enhanced. They adopted this target, but they need the member states to bit comply in order to achieve these targets, because as we know, the EU cannot do it by itself. Therefore, it created the obligations for the member states in the form of legislative instruments, primarily speaking about the Renewables Directive, which caused the intervention into the energy mix of the member states, which is guaranteed by the Treaty on the Functioning of the European Union, that the states are solely responsible for the structure of the energy mix of their own country. And then, as the idea got more ambitious of this adopted target, and still some countries, primarily in the Central and Eastern Europe, were unable to fulfill this criteria, then came the regulation creating this governance mechanism, which consisted of the monitoring and assessment of the progress of the countries. Therefore, the EU got themselves to the policy making of this country via legislative tools. The Commission was mandated to monitor, assess the progress, in particular of this national energy and climate plans. So it's important to think of the institutionalization of the energy framework and the energy union, which provided the platform for the diffusion of these, let's say, paradigms and their incorporation into national energy system structures. These tools of diffusion, as you can see, are the legally binding targets or the legally enforceable mechanisms, and shifting the responsibility for developing the national plans, which are under the supervision and monitored by the Commission, which may imply these power relations and more of the Foucauldian governmentality in the relation between the Commission and the member states. So what's going to be said is this was an assessment of the legislative framework in the EU energy policy through more of the political prism. As we can see, there's observable transposition of the values and principles into EU legislation, so-called creating these paradigms. Concretely, this example of the energy policy, energy legislation, and how it transferred. First, EU adopting the targets, then creating the mechanisms how to pressure, enforceable mechanism how to pressure the member states into the compliance, and in order to meet the Paris agreements, the UN Sustainable Goals, therefore underlining this normative role of the EU, let's say, in the global affairs, applying it. What should be done, or what should all countries do, applying in their own internal environment, and then for the other countries, and can lead other countries by example. So thank you for the attention, and if you have any questions, feel free to ask.
Thank you, Donald, for your presentation, and good luck with your research for the PhD thesis. We open the floor for questions. Yes, please, Ms. Zivig. I'm sorry.
Thank you for the floor. Well, congratulations on your great presentation and for having time for questions and answers that I failed. So I think a PhD topic is always really very good to choose something that is really, relevant. And I think the energy union is something that we are talking a lot about. So good luck with your PhD and your thesis. I have 2 short questions. You mentioned that the climate neutrality that we would like to achieve to 2050 is an ambitious target. You use this phrase, and I would like to ask you what do you think? Is it something that the European Union can really reach, or it will remain a fairy tale for the European Union that will reach climate neutrality? And the second question is, did the energy union can solve actually the EU energy dependency? because there is a huge energy dependency in the European Union that we experience, and we rely on, other sources. But I think I know that you are aware of that. So what do you think? The energy union can really solve this dependency, or we have to find other ways? And thank you for your answer.
Yeah, thanks for the question. Very relevant. The first, rather hypothetical about the 2050 targets. Under the current pathway, it's really hard to imagine meeting this full decarbonization, not only in the energy system, but let's say whole economy, which is the target. The energy is only one of the sectors. However, there are also upcoming the new climate legislation, and also being more and more ambitious and feasible energy climate-friendly legislation. Maybe we will see this slight change, and the prognosis, which I've seen several prognoses and several scenarios how to reach the 2020 decarbonization. It is possible under the most optimistic scenario. I'm rather skeptical, like that we will be getting close, but be somewhere on the halfway by the 2050. And to the second question and the dependency, yeah, it's really, really interesting, and particularly from the perspective of the Central and Eastern European country, because the idea of the renewables, domestically produced renewables, which decrease the supply and the supply dependency, which is really high, over 50% for the whole EU, 70, 80, 90% in the Central and Eastern European countries. And I will say why I picked these countries. These domestically produced renewables, they decrease the amount you need to supply from the third countries. The energy efficiency and the moderation and demand also contributed. The less you consume, the less you have to produce or to import. And in these countries still, so let's say these climate-friendly aspects got into the issue of the energy security. But maybe due also the path dependency and locking on the fossil fuels, particularly in the Central and Eastern European, the focus or the narrative of the energy security is solely on the fossil fuels. These and renewables and energy efficiency scarcely penetrated into energy security discourse. It's still focused on the natural gas, a little less to the oil, but also in these countries also the LNG terminals in Poland and interconnection, the new era, how to not being dependent on the Russia that much, but still being locked on this fossil fuel. So it's really paradoxical that the countries that are most dependent on the import of the gas are the least that consider the renewables and the energy efficiency in the energy security.
Thank you. Are there any more questions? If not, we can move on with our schedule.
Sorry for the technical issues. Thank you for the floor, and sorry for the technical issues.
It's not a problem. We all experienced it, so it's not a problem. Thank you for your presentation. So moving forward, we arrive at Mr. Christopher Mandi from the University of Szeged with the topic on international and national legal responses to the proliferation of new religions.
Yes, thank you.
Very interesting topic. And you have the floor.
Thank you. So good afternoon, dear colleagues. My name is Dr. Christopher Mandi. I'm also from the University of Szeged. I'm a PhD student at the Institute of Comparative Law. And without further ado, I would like to share this topic with you, if I can find out. Okay. So as you can see, my topic is international and national legal answers to the proliferation of new religions. And what I would like to present to you right now is just the rough draft of my paper, which will be available by December. So please bear with me. And to be sure, that's not in the traditional sense so much international as more in the supranational, so in the EU sense, as we will see. So the goal of this presentation is to explain how the international and in some cases the national level jurisdiction handles the legal problems related to new religious causes and movements. The first parts of my presentation will cover the theoretic aspects, and the second half will be about the legal problems and the specific cases related to that. So moving forward with the definition of the new religions, for the purposes of this presentation, we will have to examine the new religious movements as an important sociological factor and part of modern culture. And to put it simply, the new religious movements are the religious movements that have been founded in about the last 50 years. And these are often characterized by having, for example, a charismatic leader, strong inner ties. They have weaker forms of organization than the established religions, and some of them may or may not be millennial movements, which is related to waiting the end of the world. And there have been pretty interesting studies about that. So regarding that, they can be part of all the religions or not, the scientific consensus is that, yes, they may be an offshoot of an older religion, but usually they are not. So the goal of this study I have already stated. The methods that I'm going to apply is the study of the literature, the analysis of legal norms, and in some cases, some comparisons. And this research is considered to be an interdisciplinary one. So it's on the border of law and sociology, mainly the international or the EU law. Some aspects of constitutional law may apply, and of course, large part of it is legal philosophy, legal sociology. And of course, it has to do with the sociological view of religions. So the theoretic background. According to the ideas of the famous last century sociologist Max Weber, there was a growing disenchantment, disillusionment in the world, which was due to modern bureaucracy. And the process of disenchantment has been happening simultaneously in science, economy, art, politics, so each of these fields. Each of these domains of human action have been gradually removed from religion and the divine and have been rationalized and bureaucratized. The actors within each sphere are bound by its growing bureaucratization, hence they are locked in this famous iron cage of modernity that Weber was talking about. But there exists an opposing narrative. So this flight to the irrational is an insistence that mystical and non-rational forms of knowledge do exist. And usually it's in the source of development of sects. So Weber described new religious movements with the word sects in his age, which is kind of pejorative, but he had no other description. And they would want to resist the formal national dogmas of their respective domains. But according to some sociologists, there has been actually re-enchantment. So, for example, by the lectures of Ernest Weinrib, there has been a successful re-enchantment in the law in the 80s, as he happened to reintroduce the concepts of virtue and philosophy. And of course, nowadays, as opposed to, for example, the 1950s or 70s, there are many mystical and irrational trends, and we can be witness of a reappearance of religious ideas and a kind of metaphysical dignity as described by the likes of Weber and Emil Durkheim. So therefore, according to this trend, the religious people, or hopefully at least to our knowledge, are less marginalized by the public institutions. And moving on to the more legal part, we can see how an NRM, a new religious movement, came to be a recognized actor of the public scene, the safe scene. So there are no international accepted rules, and it differs in each country. But to my knowledge, here in Hungary, it is relatively liberal. You need 5 people to establish a religious organization. Then after 5 years of functioning, it can become a registered religion. Or in other cases, you would need 100 members or 100 years of being an international religion, then you can do it instantly. Now, other countries, for example, in the US of A, it's a bit more difficult, and that's why many organizations are not registered as religions, but actually under the non-profit civil law. And my favorite example of founding a new religion, which is the most eclatant because it's the kind of weirdest idea that anyone has ever presented in the last 10 years, is the Missionary Church of Copimism, which has been founded by two Swedish students, Isaac Gerson and Gustav Lipp. And they have found that sharing of data is a holy act, and therefore, so independently of who believes in what gods, they wanted to share this religion with the world and the internet. And after 2 years of trying, it has been declared as a legal church. So before it was only a civil law organization, but after 3 applications, finally the Kammarkollegiet, which is a part of the Swedish legal system, Swedish parliament, has declared the legal status as religion. So about the legal problems in some countries. So most of the countries don't view the NRM, the new religious movement, as a serious problem. And often they are liberal with the regulations. But in other countries, which have been very much moved by the anti-cult movement, for example, in France, in Belgium, or Germany, or even Russia, there are very serious laws, very strict laws against such expression, which may harm the right to religious freedom. So if we take the US, for example, in their constitution, the freedom of religion is very enshrined. It's a very strong value. And so far, the efforts to get the federal government to intervene have been unsuccessful. So I would like to present you a few cases from the US Supreme Court, which underlines my message. So the first 2 are about the freedom of religion, so that the religious people to choose their own way of living against the so-called state laws of discrimination. So the first case, which is Fulton versus the city of Philadelphia, is still ongoing. We don't actually know the results. But this is about a Catholic institution, childcare institution, who has discriminated that who cannot adopt children from them. And the decision is actually really important, because if the Supreme Court rules in their favor, that will mean a precedent for the religious organizations to be like above the civil law and be able to discriminate. And there has been a case like that, less important but still relevant case, which was the case of the Masterpiece Cake Shop. So in this case, there was a same-sex couple, Charlie Craig and David Mullins from Colorado, who wanted to be lawfully married in Massachusetts. And there was
I'm sorry to interrupt you. We no longer see your presentation. I don't know
okay,
if this is...
I don't see you either. So
okay, now it's fine.
It's right now.
No.
Okay, not that.
No.
So how long could you see it? Which was the last one?
You were on the cases from the Supreme Court.
Yeah, one moment. So can you see it now?
Yes, now it's fine. Thank you.
You're right. So
sorry.
There was this debate about whether this person could refuse the service, because the owner said that he refuses to serve LGBT couples on behalf that he is a Christian, and it violates his religious beliefs. So in the first court, the owner was condemned, and he was ordered not only to provide cakes to same-sex marriages, but to change company policy, etc., etc. Then in the Court of Appeals, his case was declined, and the Supreme Court actually found him that he sincerely held religious beliefs, were not in violation of the free speech and the free exercise clauses of the First Amendment, and therefore they ruled in his favor. Then there was this case, the Smith case, which was a very important milestone because it established the rights of the Religious Freedom Restoration Act was passed, and it established the rights of minority religions. So this is interesting because in most of these cases where it was so severe, some kind of substance use was involved. And as we all know, Alfred Leo Smith and Galen Black were members of the Native American Church, and they were fired because they had ingested peyote, which was a powerful entheogen as a part of the Native American Church, which was obviously a Native American themed new religion. And as the Oregon law didn't accept this, and they were discriminatively fired, they claimed that it was a crime, as there wasn't affirmative defense for religious use, and they filed a claim for unemployment compensation with the state, but the claim was denied because their dismissal was work-related misconduct. So in the end, the court ruled that the First Amendment forbids the government from prohibiting the free exercise of religion, and therefore they had to be reinstated. They were right. And the Congress in 3 years passed the Religious Freedom Restoration Act, which required the application of strict scrutiny in terms of the states allowing people to act by their religious beliefs. But at least they had won, and it was a major milestone. And this Myers case is actually funny because a person was arrested for carrying marijuana, and he claimed to be a reverend of the Church of Marijuana, which was a religion that he made up. And in this case, the court examined what does it mean to have a sincerely held belief, and they found that religion does not exempt from the state laws, and therefore his case was dismissed. But the fun part is that if he referred to being a Christian, as he later did, and he connected his beliefs to Christianity, then he might have won. So actually there's a huge discrimination against the newer religions, because if he claimed to be part of an older tradition, and no matter how removed it is, how far it is from the actual teaching, he might have won. So without further ado, there are in the different nation states different regulations. For example, France and Belgium have accepted parliamentary reports against dangerous cults. And in the first case, they have listed, the French case listed 172 movements as dangerous. And in the latter case, 189 religious entities were listed. And France was actually a pioneer because they passed the law. Not in the good sense, but in the legal sense they were, because they banned religions that undermine human rights and fundamental freedoms. And in the case of certain crimes, the law even extends responsibility from individuals to organizations. And the courts can order to dissolve organizations if their executives have been found guilty. And as we can see, this was the EU world so far, the Western world. But in the oligarchic states, there are even more severe repercussions. For example, in Russia, there have been very serious discriminations against minority religions. For example, the Jehovah's Witnesses in 2015, about 16 people were jailed because they were in connection with this religious cult. And in 2017, because of the laws on extremism, the Russian Supreme Court ruled that they were an extremist organization, they had to be banned. And in China, there is also a very widespread persecution of the so-called CLGO, the evil cults. And for this reason, the organization named Falun Gong was very strictly persecuted and banned, which is a kind of a humanitarian issue. And as we can see on the supranational level, mainly the EU level, there was to be a resolution on cults in the European Union, and it was drafted by the Committee of Civil Liberties and International Affairs. But unfortunately, it was rejected by the plenary of the European Parliament for being a too weak resolution. And the funny thing about it, that there was a strange coalition of anti-cultists and religious liberty activists who acted jointly, and they considered that it was not a matter for the European Parliament to decide, and they sent it back to the Commission. And up to this date, no new EU regulation has appeared on this topic. And some scientists have observed by the case law of the European Court of Human Rights then that in the most cases the minority religions were ruled against, and even when religious freedom was honored, it was done mostly reluctantly. So it is very interesting that the resolution uses a term cult, which has no real meaning, no real legal definition. There are more definitions of cults, but the most widespread one has to do with a social group that is defined by its unusual religious, spiritual, or philosophical beliefs, or by its common interest in a particular personality, object, or goal. But it is worth noting that not all cults are religious, and not all new religions are cults. For example, in the not too far past, there has been a self-help organization called Nexium, which was actually a very predatory cult, and they managed to rob and abuse many people, like hundreds of people, before they were caught. And in the far, but not too nice past, there was this organization called the Ku Klux Klan, which you may be familiar with, which was not a strictly religious group. It was a racist group against its common enemies. And as you can see on this cute little graph that I made, the sets which mean that cults and religions are not actually the same, but they intermingle to an extent. So most cults are also new religious movements, but most new religious movements, or at least the majority of them, are not cults. That is a difference. So to wrap this case up, I have suggested some policy changes, if they might be approved. So the resolution of cults was actually a progressive idea. So in order to set this issue right and not have extremism, but on the other side to respect the religious freedoms of the minority religions, we should set up legal definition of cults and to separate them from new religions. Then the EU should provide member states with clear instructions how to screen out the dangerous movements. And as they have originally concluded that counseling was a national task, it should not be left out as a national task. And all of this must be done with maximum respect to religious freedoms. And as the nation states know what's going on in their borders, they might like to pass laws against discrimination of minority religions, which is actually often the case. So in conclusion, to quote the words of Arthur Dykman, who was a renowned clinical professor of psychiatry, the cults are a mirror of the wider culture, which means that society is much like a cult itself, which lends itself to new ideologies and new religions being born, like almost every day. And there is a very strong human tendency to give up power in danger, which leads to dependency of so-called father figures. So in his analogy, it's like when people follow a guide to a swamp, and the problem arises when somebody steals the clothes of the swamp guide, and then he proceeds to lead the people astray. So in plain words, not all NRM are the same, and not all are even cults, but often the lines are very blurred. And also, in the modern society, there's a fine line between secularism and respecting the religious expressions, and both are needed. So in order to kind of balance the two, we should initialize a peaceful dialogue. I mean, the state should initialize a peaceful dialogue between the new religions and the media, the legislation, and government sectors. And as far as possible, the subversive groups should be screened out. And these were my sources, as you can all see. And ladies and gentlemen, I would like to thank you for your attention. And if there are
Thank you.
Then
Thank you, Christoph, for this very interesting presentation. I welcome any questions, observations from the members of the panel. Johanna?
Can I have 2 short questions, because I don't want to really interrupt the all of the presentation?
No, of course
Okay,
you may,
so,
please.
Thank you. So, because we can contact each other because we are working at the same university, I really would like to just raise 2 really short issues. That first of all, how do you differentiate between the different new kind of movements? Because some movements are quite dangerous and some movements are not dangerous. So when it comes to the legislation, how can you differentiate between the different movements? This is my first question. And one relating question connects to the European Union's competences when it comes to the religious aspects of legislation, because when you are talking about the EU legislation, you always have to consider the competences of the European Union, whether the EU has the competence to really regulate these kind of aspects of the national law. And one more question, do you know any kind of information how Hungary, or for example, Central European countries, considering new religious movements when it comes to the society? So are we really welcoming them, or we restrict from these new religious movements? Thank you for answering my question, and thank you for the opportunity.
You're welcome. So I would like to answer your questions in my order, because some things are kind of mixed up in my mind. So I would like to answer the last question first. So the sociologists in Hungary have found, and it was in about the beginning of the last decade, that actually Hungary is pretty open to these. So as far as the media goes, they were not trying to denigrate them, not trying to disrespect their rights. And actually some of them were very sympathetic towards them. And for example, if we have the Hare Krishna movement, it's very widespread in Hungary. It has a huge base in Hungary, and very many new religious movements have been made since the 90s. Unfortunately, the government is kind of biased against them, because it tends to draw support from the large established religions. But according to this new law, which has been passed in, or actually not passed, it was amended the last year, you can establish a religious organization pretty fast. As I have mentioned, you only need 5 members, and then you sign the documents, send it to the court. So it's the regional court that has to decide on this matter, and it is like a regular organization, just it is a religious organization. So in the name you have to include that it's religious, and after 5 years of service, then you may apply to be a registered religion. So I hope that answered your question. And the other 2, because I forgot the second one. The first one, I think if the member states are to screen the dangerous organizations out, then, for example, you could utilize the aspects of big data. So, for example, if they have Google searches, or in the patent that when they founded that religious organization, there are some kind of keywords, and you could like research them. And if they contain some element, some radical element, then they might have to be examined closely. And in all the other cases, we just have to respect their right to believe whatever they want to believe.
Thank you. I won't repeat my second question because we have to fit in time. I've just read it, so I think we can discuss our stuff at the university as well.
Thank you very much.
I'm sorry for the time restraint. Actually, I had a question, but I think that we can move forward with our schedule to Mr. Benche Krusowski. I'm sorry. His topic is on the codification of the first Hungarian competition law. Please, you have the floor.
Thank you for the words, Ms. Moldovan. Welcome, everybody. My name is Bence Krusowski from the University of Szeged, and I'm a PhD student in the Hungarian Legal History Department. So we will end this panel a very interesting law history research. My research is the first Hungarian Competition Act, and in the next few minutes, I would like to talk about the codification of this act. I share my screen. Okay. Probably. Okay. So the first draft of the article on unfair competition had been formulated by 1901, and after its creation, the Ministry of Trade intended to ask for the options of all competent professional associations and chambers. The National Industry Association, which can be regarded as the largest professional representative organization of the area, may throw a comment on the draft they had been sent. The organization discussed two subjects primarily. On the one hand, whether the necessary protection against unfair commercial practices should be provided by a separate law or the existing law. On the other hand, they examined whether the adoption of the law was timely. Minister of Trade Sándor Hegedűs stressed that they could have found tools even among these existing provisions that would have made it possible to act against the abuse of unfair competition in stricter that would have made it possible to act against the abuse of unfair competition in a stricter and more effective way. However, he still thought that the adoption of a separate law was justified. He said, given that other laws, due to their uncommon purpose, couldn't have given adequate protection against the well-known growth of unfair competition, and also considering that the fact that measures which are somewhat suitable for preventing unfair competition sporadically exist, doesn't make it unnecessary to create a consistent law covering this subject entirely. Basically, the draft was created in the week of industrial freedom. It intended to provide defense against the abuse recognized in the practice of commercial and industry, which were intended to be carried out with despicable, unethical, unfair tools in free competitions as well. Even though Article 5 of 1923 had not even adopted the frame of the current draft, several principles regarding the spirit of unfair competition were prominent in it. For instance, the draft dealt with the category of free competition in detail. Anyone can use all their knowledge, talent, and diligence in competition. Therein lies the freedom of industry and commercial traffic. It stressed that if a craftsman or tradesman isn't shy away from unethical acts or the infringement of public order, restrictions have to be made. As what freedom means, it isn't that we can violate other people's rights, but everyone can practice their rights undisturbed. The draft contained viable thoughts in connection with the definition of unfair competition. First and foremost, it emphasized that the definition of them is difficult, and basically it means that the tradesman or craftsman caused damage to his competitor by his unethical acts for businesses' competition purpose. Despite this, the second draft, urging to end unfair commercial conduct, got stuck in the draft stage. One reason to that was the objection of the representative organization of the interest with the draft, since they unanimously regarded the creation of a law as untimely. The Košice Chamber of Commerce and Industry gave the following opinion on the issues. In both cases, nevertheless, we are badly referring to the fact that the situation of our economy differ from those of Germany significantly, and the creation of a law that wouldn't mimic the German law and wouldn't take the Hungarian situation would hardly benefit for developing economic life. Hungary's economic relationship with Austria, referring to the principles of compromise, as in this question, the only way it could have been ultimately defend and even adopted new law. If the Austrian government had put a similar law into force, constituted a further reason. The next milestone of the legislation in connection with unfair competition can be dated to quite late, only 7 years later. On the one hand, it could be explained by the fact that Sándor Hegedűs, after his departure, was succeeded by the new Minister of Trade every year, and on the other hand, by early 1907, the Austrian House of Representatives had adopted the law proposal on stopping unfair competition, as the above-mentioned obstacles of making a new law were seemingly removed. The second draft, which was very similar, the first draft, made by the Ministry of Trade by Ferenc Kossuth, basically followed the German law of 1896. However, while the first Hungarian law of 1901 followed the German law word by word, so to say the new draft perceives the subject of unfair competition individually and used the Austrian law draft in only a small part as well. The most significant difference from the proposal of 1901 was the second draft described each unfair conduct more accurately. From this draft, it was clear that the legislation intention was the proceedings to be imitated on the basis of the draft to be permanently defense primarily, in fact, on prevention of more serious impairment of rights. The destructive power of the 5-year-long war adversely affected the ethical standards of Hungarian commerce as well, and uninvited intruding elements have also profited in our business life. During the years of peace after the wars, Hungary's commercial and industrial life started to rapidly grow. The free competition began to make itself felt with renewed energy, inducing fires and miraculous commercial practices that we had never seen before. Commerce and industry started to experience themselves what to the total breakdown of the discipline, the undermining of authority, and the losing of business fairnesses felt like. All commercial and industrial associations agreed that the making of an independent special law has become necessary in order to deal with the problem as soon as possible. The state has to intervene where experience harm caused with deceitful, unfair means or oppression or such intention. Beyond the prolific, unethical business conducts in our commercial life, thought further reason also urged the making of our long-awaited commercial law. On the one hand, the Trianon terms of peace within the framework of the economic provisions obligate Hungary with Article 210 to do its best to pull down the unfair competition. On the one hand, with several international agreements such as our accession to the Union of Washington, registered by Article 9 of 1913 on the protection of industrial property, it became an obligation to provide an effective defense against unfair competition for the citizens of the Union. In light of these circumstances, it was clear that the codification of the competition law would continue. The proposal for the law draft on the defense against unfair competition, the third one now was made by June 1921. In the subject of the preparation of the law on unfair competition, Minister of Trade Lajos Hegyeshalmi called a meeting where university teacher Rödön Kunz and ministerial counselor Elemér Balázs presented the proposal for the draft. The correspondent of Pesti Hírlap reported on it. The ministerial justification of the law proposal of unfair competition was made and registered shortly thereafter on 21st December 1921. Nothing proved better how urgent a task was the creation of a forced competition was regarded by legislation than the first three chapters of general jurisdiction of the proposal, in which it was stated that the earliest possible realization of the effective defense against unfair competition is an essential necessity, and it is a significant national interest in order to clean and strengthen the national commerce and improve our foreign relations and credit. In this present study, I don't intend to present and analyze the detailed provision of the law proposal of Article 5 of 1923 or those of the law itself. However, it is important to note that the guiding principles of the present proposal took the German competition law adopted in 1909 as the basis. Those in the first section of the law proposal, the general clause without an exhaustive list was set up stating the business competition mustn't be carried out in an unfair or unethical manner. Therefore, the proposer sanctioned activities which would not have been immoral otherwise, but according to the public perception with the business competition, they were considered unfair aspects of business competition. So in my opinion, this solution was really fortunate since the category of commercial fairnesses didn't completely cover the private law concept of accepted principles of morality. As a matter of fact, by the starting point in case of accepted principles of morality has to be searched in the popular perceptions of the particular area, the starting point for business fairnesses was provided by a much narrower section, namely the perception of tradesmen and craftsmen. However, I would like to draw attention to possible fault in the completed law proposal. The theoretical standpoint of the proposal was to keep the provisions regarding the related materials in force. In addition, according to the section 43 of the proposal, by the law in trying into force the provisions of existing acts that once were non-compliant with the law and the try to regard this subject, general rules of law interpretation would have applied. In this case, however, the proposal was trying to regulate legal relationships that were the same as the existing legal provisions, and it did all this in a manner that in case of maintaining the provisions regarding the later two acts would have applied to the same legal relationship. For instance, the unauthorized use of business described in section 24 4 of the Commercial Code competed with the rules laid down in Section 7 of proposal. The solution of the proposal would have resulted in various and uncles in practice. In conclusion, we can see that even as a result of an over 2-decade-long codification process, Article 5 of 1923, the law providing defense against unfair business practices was born in Hungary. Like a concert gone wrong, little music and a lot of breaks. This is how the poor events were replaced by the long wait. Salamon Beck explained after the law came into force on 15th May 1924. Shortly before the outbreak of the war, the commercial and interest made a powerful step in order to make the stock cart of the codification moved, and they founded the Association for Protecting Business Premises. However, its work was halted by the outbreak of the war. We could see that the peace treaty and the further international agreements made the topic relevant again, although the obligation undertaken in the peace treaty didn't set a deadline regarding the creation of the law, it still brought forth the enactment of the law. Despite this, as it is mentioned above, in the justification of the law proposal, the creation of law wasn't presented as an obligation undertaken in the peace treaty. During the discussion of the proposal at the National Assembly, the Minister of Trade correctly pointed out that the law against unfair competition would have been born without the foreign relation. Despite the fact that our national competition law was not born until the early 1920s, we have to see that after the entry into force of the first German competition law of 1896, the first Hungarian law proposal was viable, especially soon. So it is safe to say that there was an absolute intention in the Hungarian legislation to rapidly react to the changed circumstances caused by the challenges of the commercial competition. By creating foundations for our national competition law, Article 5 of 1923, could also serve as an adequate base for our subsequent development in competition law. So thank you for your attention.
Thank you for your presentation. Very detailed presentation. Any questions, observations are welcome. We still have time, so.
So I have a question.
Please.
I really like your presentation.
Please.
It was very in-depth and it was very academically gifted. But I would like to know, when was the next commercial law approved in Hungary? And did it follow a very different model? So you mean that, or you said that this followed the German model, and the next one then followed the Soviet model, or what?
Soviet model. We always use the German model, especially. So the German model, and after this we use the Austrian Competition Act, and we adopted a lot of articles from the Austrian Competition Act, especially in the general clause, which we adopted in the first paragraph. And at the moment, the Competition Act is the 1996 Act, use the same general clauses.
I understand. Thank you.
Okay, thank you. If there are any other observations or remarks, we still have time, so. I guess not. That means that we can close this session. I want to thank you all for your presentations. We had a very fruitful legal journey from competition law, ecocide, and energy policy, and proliferation of new religions. Actually, I have a short question on that, if I may. If it's
Of course.
About Christoph. We always see a religion and religious beliefs as something very sensitive, and subjective issues. So why should international law and national law find remedies for the proliferation of new religions?
Well, it's not strictly about.
I mean, what is the problem, legally speaking? I know it's not a nice question. I know, but
okay, it's a very good question actually, and thank you for asking that. So in previous presentations, I think I've had about 3 of them, one of which was yesterday. So
okay,
I have presented the issues where there have been issues of cultic violence. So, for example, in the 1990s, this was very, very prevalent. So starting from the 1970s, there was the issue of Jonestown, which was a huge mass murder of the devotees, and it was very brutal and very tragic, and actually this paved the way for religions to be persecuted by the governments in the 80s, 90s. And then in the 90s, there was another wave of violence. For example, in Japan, there was a cult called the Om Shinrikyo, which led to a very bloody accident. There was a subway explosion in Tokyo. Then there was this Order of the Solar Temple, which was a crusader team movement, religious movement, and they also committed very bad, very heinous acts. So there was a legitimate fear from these governments and a legitimate pressure to act on behalf of the European Union. So in that case, I would say that it was very founded in the 1990s. It had a very stable ground to do so. And in the following years, obviously, a lot of things changed. So with the digitalization, with this more modern culture, the pressure to be a part of a religious movement has obviously declined, because nowadays you can, for example, go to yoga online, do meditation online, and absorb all kinds of beliefs which were not present in, for example, the 20th century culture, or if we go back, then the 15th century culture. So yeah, it's a very difficult subject, but in those times, I would say that they had the right to persecute the dangerous movements. So I hope that answered your question.
Yes, thank you. So violence is the main problem, and that justifies the interest of state and international law, generally speaking. Thank you. So I want to thank you all again. Your presentations show that you are very passionate about your subjects, about your topics of research. I am really delighted to meet you, and I hope that we will meet again, maybe in normal conditions. It was a second session, predominantly. And I hope to see you soon. If anyone has anything else to say, please do. If not, once again, thank you and for sharing your ideas with us, and stay safe. Hope to see you soon.
Thank you for having us. Good to see you all.
Have a nice day. Stay safe.
Thank you for the opportunity. Bye.
Bye-bye.